Hi all, Keith Carlson at Carlson Jaguar wanted to bring you a few more cases from the middle of October that we've been looking at, mainly out of the California Courts of Appeal. First up is Gorobets versus Jaguar Land Rover. This case involves a CCP Section 998 offer. It's an offer to compromise and resolve a matter. And if the other side rejects it, the costs can shift to the one who rejected it if they don't get a better result at trial. It's a statute that's designed to promote settlements in California. In this one, Land Rover made two simultaneous 998 offers to compromise, and the court was then examining whether you can do two offers at once. And the short answer is no, you can't if both are valid 998 offers. That's the key to this case. You can make multiple 998 offers in sequence, but only one at a time. Here, one of the two offers that was offered simultaneously, however, was invalid because of its uncertainty, a requirement that the offer be certain and the court can figure out and the other party can figure out what the thing is supposed to be worth and help the court determine who prevailed after trial. In this instance, only one of Land Rover's offers to Gorobets was certain and thus a valid 998. So even though they offered two, which you shouldn't be able to do, one wasn't valid, and therefore the court determined that there was only one that was at issue. Gorobets had rejected that and then didn't beat the offer at trial. Thus, the appellate court was willing to have the cost-shifting measures go into place. So in essence, Land Rover kind of got lucky on this one because one of its two offers was invalid. Otherwise, they wouldn't have got their cost shifting, but as it turns out, they're going to. Next up is another arbitration case. We've been talking about these of late. Most of the cases coming down seem to be somewhat unfavorable towards what was previously regarded as a public policy in favor of arbitration in California. This one is not employment related, however, as the last few videos have been talking about. This one was in a consumer sales contract. I bring it up because the underlying reasoning seems that it would be applicable if you were in an employment setting, although one would wonder how you would have gotten that far under these facts. So a salesperson shows up to an elderly couple's home. They're in their 90s. Turns out they have dementia, and he gets them to engage in a contract to do some home repair and solar installation. The dispute ensues. The solar Mosaic moves to compel arbitration, and the court denies that, saying the couple had lacked capacity to sign the arbitration in the first place, so there was going to be no arbitration in that matter. So I think anyone being involved in an arbitration agreement is going to have to look at the capacity of the other party to enter into the agreement. Next up is an insurance-related case with some interesting facts and proceedings going on for those in healthcare. People versus Kaiser Foundation Health Plan. California's Attorney General went after Kaiser's health plan for not updating its provider directories as required by statute. Kaiser then prevailed at the trial level with a motion for summary judgment, arguing that the trial court should not engage in adjudicating the action, it should abstain. The case was involving, as I mentioned, the California Attorney General and also the Department of Managed Health Care. And there were multiple theories on why the state felt that it should be allowed to sue, including that it could have standing under the unfair competition law, Business and Professions Code 17200, as well as a false advertising statute. The trial court, however, sought to avoid playing the role of a state agency in deciding what really should be decided by the DMHC, and therefore abstained, allowing for it to grant the motion for summary judgment in Kaiser's favor. The Court of Appeal, though, reversed the MSJ order, saying the trial court should not have abstained and it should have decided the case on the UCLA and false advertising claims. So an interesting back and forth on judicial abstention, 17200, false advertising, the Department of Managed Care and healthcare plans updating their provider directories. A few cases we've been taking a look at here in the middle part of October. Let us know if you have any questions or would like us to follow up on any other matters. Thank you.